Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, stumbled over that, and Dennis Hall, LLG Bulletin Editor. Hi, Dennis.
Hi. Hello, everyone.
Now, last week I had the absolute delight to attend the SLCC, that's the Society of Local Council Clerks, at their conference in St George's Park, and I delivered a session on the Public Office Accountability Bill, and I was delighted to see our corporate partners, Wilkin Chapman Rollett, in the form of Jonathan and Estelle there as well. And I really couldn't have had a warm welcome, so thank you to Michael, Rob, and all the SLCC team for a great day. It's really warmed me up, Dennis, for the LLG Spring Conference, just a few months away now.
Well, indeed, I'm very much looking forward to it. It'll be here before we know it, Helen. And the conference is, of course, already available to book on the LLG events page. But first now, let's turn our attention to the first item of this week's Grapevine. And we turn to GCHQ's National Cyber Security Center, who have issued a warning specifically that Russian state-aligned hacktivists are targeting local government. The centre said that hackers are persistently targeting UK organisations, but particularly local government and operators of critical infrastructure. It recommended that local authorities review their defences and improve their cyber resilience by preparing and being able to respond to what is termed denial of service attacks.
That's right, Dennis. And it also encouraged organisations to engage with the NSSC's heightened cyber threat collection. Now, the NCSC, that's a difficult set of letters there, said that while DOS attacks are typically low in sophistication, a successful attack can disrupt entire systems, costing organisations significant time, money, and operational resilience by having to analyse, defend against, and, of course, recover from them.
Indeed, and NCSC Director of National Resilience, Jonathan Ellison, said, by overwhelming important websites and online systems, these attacks can prevent people from accessing the essential services that they depend on every day. He said all organisations, especially those identified in the alert that's been released, are urged to act now by reviewing and implementing the NCSC's freely available guidance to protect against DOS attacks and other cyber threats.
Yeah, the alert, which sets out guidance on how to mitigate DOS attacks, can be found on their website, and the NCSC is advising all organisations to review their defences and to improve resilience against attacks from Russian-aligned groups. And in particular, they're encouraging all organisations to review their DOS protections, which of course includes understanding your service.
Indeed, there are probably many points in your own service where an attacker can attempt to overload or exhaust available resources, thereby preventing you from serving legitimate users. You should understand where these points are, and in each case determine whether you or a supplier are responsible. And now here's another piece of terminology. Upstream defences. Ensure your service providers are ready to deal with resource exhaustion in places where they are uniquely placed to help. We recommend, they say, that you should understand the denial of service mitigations that your ISP has in place on your account.
There's a lot of new terminology, and
there's
so much I'm unfamiliar with, and something else is building to allow scaling. So what this is about is making sure that your service can rapidly scale. Ideally, you should be able to scale all aspects of your application and infrastructure, and define your response plan as well. So designing your service and plan your response in advance to an attack so that it continue to operate, even if it's in a downgraded fashion.
Yes, exactly. And finally, testing and monitoring your service. Gain confidence in your defences by testing them, and ensure you can spot when attacks start by having the right tools in place. Test your defences so you know the types and volume of attacks you're able to defend. System monitoring will help you spot attacks when they begin and analyse your response while it's underway. Really, it's all practical advice wrapped up in all of this terminology, Helen, but important things for local authorities to start thinking about.
Yeah, and I don't think lawyers should be scared about the terminology either.
No.
I mean, I know just listening to that, it was I mean, even I was struggling through to really understand the semantics of it. But I think as lawyers, we've got a lot to bring in just asking the right questions, essentially,
Yes.
and bringing this to the attention of the people that do understand a bit more about
Yes.
the speak. Yeah.
To use that phrase, we need to be in the room on this, especially given the nature of the risks that are involved.
Completely. Absolutely. Now, let's move on to another matter, something I'm slightly more familiar with, the draft Commonhold and Leasehold Reform Bill. Now, this represents one of the most significant updates to property law in England and Wales in recent decades. And its central objective, I would say, is to rebalance the relationships between homeowners, landlords, and developers by modernising frameworks widely seen as outdated and addressing long-standing structural inequalities within the leasehold system. Now, a key policy shift is the move to establish Commonhold as the default tenure for new flats, reducing reliance on leasehold arrangements that have historically limited homeowner control, Dennis.
Yes. The bill emerges from well-documented issues and concerns in the leasehold sector, where millions of homeowners face depreciating lease terms, complex charging structures, exposure to forfeiture and unregulated ground rents, and these factors contribute to a persistent power imbalance between leaseholders and landlords.
Yeah, absolutely. When you look at forfeiture, for example, is really quite archaic.
It
Um,
is.
Although Commonhold was introduced, now listen, 2002, that was a surprise to me. It
Yes.
has seen minimal uptake due to what some commentators refer to as inflexibilities in the original legislation and difficulties in applying the model to mixed use or large developments. And I think as well the commercial incentives associated with leaseholds. So the Law Commission's extensive 2020 review highlighted the reforms required to make Commonhold workable. And that, in fact, shaped much of the bill's design.
Yes, and to support Commonhold becoming the standard model for multi-unit buildings, the bill does introduce several structural reforms, and these include expanded development rights for developers, the ability to create sections for managing mixed-use sites, and the use of separate heads of costs to ensure a fairer allocation of expenditure. Collectively, these changes aim to make Commonhold more adaptable across a wider variety of building types and development scenarios.
Yeah. And the bill is also designed to strengthen the Commonhold Community Statement, known as the CCS, the central governance document for Commonhold. That's what that is. And reforms include clearer voting procedures, mandatory reserve funds, compulsory public liability insurance, interesting, and updated director appointment processes. And of course, there's a lot of changes to company law as there is in that regard. These measures are intended, so say the government, to support transparent management, financial resilience, and more effective dispute avoidance.
Alongside Commonhold reform, the bill makes substantive changes to existing leasehold law. It abolishes the forfeiture regime that you mentioned and replaces it with a court-supervised enforcement scheme that maintains landlord remedies while preventing the loss of a home for relatively minor breaches. Ground rents, and this has been in the news, ground rents in existing leases will be capped at £250 per year, reducing to a peppercorn after 40 years, helping mitigate financial pressures without destabilising the market.
Mm. For freehold homeowners on private estates, the bill removes the historical, quite frankly, severe enforcement powers attached to estate rent charges, and it replaces them with what look like proportionate modern mechanisms.
Yes. Conversion from leasehold to commonhold will also become more achievable. The bill lowers the consent threshold from 100% to 50% of qualifying leaseholders and introduces transitional arrangements for non-consenting leaseholders whose rights will be aligned with the commonhold model until their interests can be phased out.
I think overall the bill does mark a deliberate legal and policy shift towards democratic owner-led property management, which aims to deliver a fairer, more transparent and sustainable tenure landscape. But we will need to wait and see as ever.
Indeed.
Now we're going to return to a firm standing item of this last quarter. I would say we've of course been charting throughout the podcast the developments in respect of Mazur, and there's more news.
Indeed, Helen, the fallout from Mazur continues. Legal executives now say they are waiting for months for their practicing rights to be granted under the new procedures that have been recently adopted.
That's right. Silex regulations said last week that applications to be authorised to litigate are taking an average of 9 weeks to be completed, and individuals have gone through the process say their wait has in fact been much longer. They also report finding it difficult to speak to anyone for an update on their applications. Now, the issue is important because following the High Court ruling, and we've talked about this a lot, hundreds of legal executives are in fact unable to litigate, and their work is heavily restricted.
And many have had to step away from both cases and clients that they've had for many years in complex matters, and are having to defer to supervisors who might be newly qualified solicitors. Now, the judge in Mazur ruled in September that only authorised individuals could conduct litigation, and that any firms allowing unauthorised people to do so, even under supervision, are acting unlawfully. The entry points currently offered to legal executives are what is known as the portfolio route, and this means submitting evidence of competence and experience in litigation, assessment only, and finally a training and assessment route.
Yeah, I think what members should bear in mind if they're trying to access the portfolio route is that quite a number of elements of evidence within it simply won't be attainable by local government lawyers because they won't do that type of practice law. But Silex have advised LLG that they are more than amenable to looking at sort of comparable types of evidence. So don't be afraid to have those discussions and put forward other illustrations that might be of use to you. But in January, Silex regulation published this update revealing that 67 people have been approved as litigators since the start of November. However, the organisation has received 405 applications under the portfolio route, and 37 have been approved, and that was at the point of that report. Now, in response, a Silex regulation spokesperson said it recognises the ongoing uncertainty facing many chartered legal executives and is working hard to assess and approve as many portfolio applications as quickly and as efficiently as possible. That's their response.
Yeah, and they say they've introduced a new applications process. That was on the 1st of November last, and they've hired 20 external assessors to increase capacity. And the spokesperson added, there are applications that have taken longer than 9 weeks and some that have gone through much quicker, and this often depends on the quality of the application and whether all steps have been completed. For example, they said a significant proportion of applications have required additional information to pass pre-screening and, once with an external assessor, to be approved. We are working closely, they say, with their external assessors to ensure that everything they need to assess the applications can be done quickly and efficiently.
Well, I think it's worth noting here, just adding that in respect of the appeal, which is due to take place soon, a few weeks, 26th of February, in fact, we now have the Association of Personal Injury Lawyers having been granted permission by the Court of Appeal to intervene in Mazur. So that intervention list is starting to get quite long now, Dennis, I believe.
Yes. It's helpful.
I'll flag just here, please do, for our membership, please do register for 2 events we're holding for members via our events website. The first on the 4th of February on assessing the practical impact of Mazur on local authority legal services. This is a session on Mazur. It's designed for legal services managers, but anybody else, with an interest, because it's looking at what the Mazur judgment might mean in practice for local government teams working in a number of litigious areas, including those areas that might sit outside of legal services. So it's looking at doles, send tribunals, deputyships, etc., etc. It's not a summary of the Mazur judgment. We're not going back over that. And it does not cover what activities might comprise ancillary functions, but it does look at a lot at what client departments might be doing.
Yes, and importantly, the session may help you to think about a risk-based approach for your legal services teams and tackle areas of risk elsewhere in your organisation. Then on the 11th of February, we have the Workforce and Employment Support following Mazur. And this is a special LLG webinar hosted by Sarah Lamont and Daniel Purcell from leading firm Bevan Britton that specially looks at the guidance on employee relations challenges as a result of the Mazur case.
Yeah,
I
so
think that's
again,
something to look forward to, Helen.
I think so. That really is about the individual and the employment issues relating to it, as opposed to what the judgments caused as well. So that's definitely something our membership asked for, and we're delighted we're able to provide it. Now let's change subjects, Dennis. I don't know if you've ever heard of the Eagle Club before last week.
I've been asked a lot of questions over the year, Helen. Funnily enough, no, I haven't.
Yeah, I hadn't either, but recent reporting by the Law Gazette and Legal Futures has highlighted growing concern amongst in-house lawyers over the Law Society's draft whistleblowing guidance. Now, according to coverage in both those things, but we've linked the Law Gazette in the bulletin, the Eagle Club is a global network of senior female general counsel, and it was funded by Leslie Wan. And it has she in particular, but the organizer, the club as it is, has sharply criticised the guidance, arguing that, quote, it falls short in a number of areas and risks exacerbating current problems faced by the in-house community.
Interesting. We should look at this. The
Yeah.
Law Society produced the draft guidance in response to ongoing questions about how solicitors should navigate the reporting of wrongdoing while maintaining their duties of confidentiality and legal professional privilege. Now, the tension between these obligations has come under renewed scrutiny following the post office scandal, in which in-house legal teams were criticised for failing to escalate concerns.
Yeah, and the Eagle Club's central objection, and it was reported by both Law Gazette and Legal Futures, as I've said, because they don't have their own website. It's all available through LinkedIn. And I'm not entirely sure. I think you might have to be invited into it. I can't be sure. I think some is open access. But their central objection is that the guidance creates a, quote, contradiction and an impossibility by suggesting that in-house lawyers must simultaneously report misconduct and maintain confidentiality. And as the organisation put it, what cannot both disclose information and keep it confidential?
Well, precisely. And their response also warns that the current framework actually exposes in-house lawyers to personal and professional risk. And this might include fines, breach of contract claims, or even regulatory action if they disclose privileged information. Instead of protection for whistleblowers, the Eagle Club argues current rules create fear and uncertainty. Legal Futures further reports that the group has urged the Law Society to withdraw the guidance and work jointly with the Solicitors Regulation Authority to produce a single, cohesive framework that reflects both all the realities of in-house practice.
Well, I think that would be eminently sensible, Dennis, because, of course, the Solicitors Regulation Authority has itself published guidance to in-house lawyers about, how they should work and what they should do. And I think I would think this would definitely be a collaborative piece that should be entertained between the two entities, frankly. But let's take a look at what the Law Society has said in response. So a spokesperson has said that the organisation recognises the difficulties created by privilege restrictions and invited feedback through its consultation, emphasising its aim to strengthen support and protection for whistleblowers in future iterations of the guidance. So I think Leslie Wan would be a really interesting person to talk to, Dennis. There's
Definitely.
There's some synergies there. And if you're listening, Leslie, please do get in touch with me. Now, the moment we've all been dreading, we cannot get through this edition without mentioning elections.
Can't.
No,
well,
Dennis.
Helen, there just hasn't been enough time to draw breath with the rapid series of announcements from the government on the issue of postponing elections. So I've posed the question, where are we now on this? Well, of course, LLG was quick to put out news of which councils will or will not hold elections in May. The government has confirmed plans to postpone elections for 29 councils in order to allow them to focus on local government reorganisation.
Yeah, Whitehall proposed delaying elections last year for 63 councils in order to allow them to focus resources on replacing their two-tier local authorities with unitary councils. And a statement on Thursday, the 22nd of January, said that the 29 local authorities had, quote, provided sufficient evidence on how postponement would release capacity to help deliver local government reorganisation.
And the remaining 34 councils are going through reorganisation and will hold local elections in May. Where elections are postponed, existing councillors will have their terms extended. Elections to the new unitary councils are expected to take place in May 2027, with the new councils expected to be up and running in April 2028. Now, the announcement comes as Reform UK pursues a judicial review challenge to the postponement of elections. A divisional court is now set to hear the claim on the 19th and 20th of February.
Am I right in thinking the 19th is some sort of preliminary permission?
Well, in these judicial review cases, it would normally be that, but I've looked further into this, Helen. This is what they call a rolled up case, and it will be, the permission aspect will be dealt with first. And normally there would be a separate hearing, but the court has already indicated in directions it will determine the matter if it gives permission for it to proceed. So this rolled up hearing where everything will be dealt with will be on the 19th and 20th of February. Important dates.
Very important dates. And I would suspect that we wouldn't have to wait too long for judgment, because I think the court's already indicated simply by giving permission out of time, it wants to deal with this quickly.
Time's of the essence on this.
Yeah, and they must have expedited for that date to some extent. Yeah, because of the listings. Well, barristers at 11 kbw have said that the Secretary of State is, quote, in the meantime, not prohibited, should he so decide, from laying an order under Section 87 of the Local Government Act 2000, which would postpone certain local elections. And don't forget, a parliamentary petition of over 135,000 signatures has also triggered a debate in the Commons. Now, in a letter to the councils, the Secretary of State for Housing, who's Steve Reed, said that the delay, quote, ensures our continued delivery against the ambitious timetable for reorganisation, which has been their line all along.
It is, and he went on to say, by delaying these elections, I'm confident that we will be releasing essential capacity within councils to allow their teams to focus their energy, their full energy, on the complex reorganisation process, while also addressing concerns regarding the cost of holding elections for bodies that will soon cease to exist. And Reid went on to say that the legislative process to postpone the elections will now commence, and the necessary statutory instrument will be laid as soon as possible.
Well, an explanatory memorandum will also be published alongside the statutory instrument, which will give more detail about the representations received, as we understand it. The Ministry, meanwhile, of Housing, Communities and Local Government said, quote, I'm going to quote, about 1 in 3 people in England currently live in an area covered by 2 local authorities, creating duplication and waste, 2 chief executives, 2 sets of councillors and 2 finance directors. There are shared services in place, though, in terms of some of those roles. She went on, streamlining councils will eliminate that confusion and duplication, so more can be spent on the things the public want, caring for older people, fixing potholes and creating greater places to live and work. And the minister said that the reform will cut the number of councillors by around 5,000 and eliminate highly paid senior roles, freeing up cash for local priorities. I'll just say, Dennis, all of that it relates to why local government reorganisation is happening, as opposed to elections. But
yep, fair point. And you'll remember that on Monday, that was the 19th of January, the government has already called on 4 councils to clarify their requests on postponement ahead of their decisions, claiming the local authorities' representations in these cases made no explicit requests either way. All 4 councils, Essex, Norfolk, Oxford City, Southampton City, all of them have since been included among the list of councils that are set to have their elections postponed. But Helen, the story is far from over.
It is far from over. And actually, there might even be a change in respect of Essex. And I hate to muddy the waters, because I know it's always in and out. But I think there might be a suggestion that position might have changed. I don't know, Dennis, as of this moment. So I think we'll just run with what we previously knew, which is that they are postponed. I don't know for sure.
It's a moving picture, isn't it?
It is a moving picture. So we will of course report on the judicial review outcome when we know more, and no doubt we'll do a special feature on it as well. Now let's move for our final item. We don't do this too often, like have a look at case law, but I actually wanted to go back to my roots in housing, where I kind of started out, and examine the case of Sandwell Borough Council and Anne Marie Harris. Now, this is to do with introductory tenancies, actually. Bear with us, we'll try to present it as cleanly as possible. Sandwell Borough Council has won a case over an introductory tenancy after a judge admitted it had been difficult to resolve, with sound arguments on both sides for the opposing contentions as to the meaning of Section 130 of the Housing Act 1996.
Now, Section 130 applies when a landlord has begun possession proceedings for a dwelling house let under an introductory tenancy, and either A, the trial period for the introductory tenancy ends, or B, one of the events in Section 125, subsection 5 occurs, that is to say, events that bring an introductory tenancy to an end.
Yeah, so in this case, there were 4 questions which arose. So the first was, how must a county court appeal be brought in a high court district registry? Secondly, around timing and tenancy status, does failing to bring an appeal in time end the trial period and or the introductory status? 3, can a later extension of time to appeal prolong an introductory tenancy? And 4, where first possession proceedings have ended, can Section 130, subsection 1A of the Housing Act 1996 operate again on a subsequent set of possession proceedings to keep the tenancy introductory? It's interesting, Dennis.
It is. Back to Section 130. This preserves introductory status after possession proceedings are begun until either 1, the tenancy ends under Section 1271A, or 2, the proceedings are finally determined when withdrawn, or any appeal is abandoned, or the time for appealing expires without an appeal being brought.
Well, Sandwell started first possession proceedings with a notice to terminate in January 2023, and those were dismissed on the 30th of October 2024. It's quite a long time scale there. And Sandwell attempted to appeal. Now, a dispute then arose as to whether its appellant notice, which was handed in at Birmingham District Registry, was validly filed because of the electronic working pilot scheme and the local e-filing expectations. Now, that Birmingham registry later told Sandwell to refile via e-filing, and Sandwell did that on the 28th of November, and it obtained an extension of time for Judge Ritchie on the 16th of January 2025. But meanwhile, and I can see why they did it, Sandwell served fresh termination notices in January 25 and issued second possession proceedings on the 4th of April that year. And this Deputy District, can't get my teeth in, Deputy District Judge Sewell refused the renewed permission application in the first proceedings on the 7th of April 2025.
Now, the central arguments from both sides were this. The tenant argued that electronic filing was mandatory. The first appeal was out of time, so by Section 130, subsection 5, the first proceedings were finally determined on the 20th of November 2024, converting the tenancy to secure status and, via Section 125, subsection 6, preventing any return to introductory status. The second claim could not invoke Section 130 again. Now, the landlord argued that Practice Direction 51.0 did not clearly mandate e-filing for High Court appeals from the County Court. The paper filing on the 18th of November 2024 was compliant with CPR Rule 52 and Practice Direction 52B. Alternatively, time was in effect extended.
Now, I realise this is quite heavy, but for housing lawyers, it's gold dust, and they don't often get a lot of coverage in the podcast. So, on appeal, it was held by His Honour Judge Grimshaw that the practice direction did not clearly displace Rule 52 and Practice Direction 52B for these appeals because, and this is important, electronic filing was not conclusively mandatory. The appellant's notice lodged on paper back in 2024 was a permissible filing. So the appeal was, in fact, brought in time, and the Deputy District Judge, in consequence, erred in holding otherwise. The other thing he held was that an extension of time does not retrospectively make an out-of-time appeal in time. But here, in any event, the appeal was, in fact, in time on its own footing because the paper lodge was permissible.
The respondent's notice was rejected. Section 130 can apply to a later set of possession proceedings issued while the earlier proceedings, including the appeal, are still extant. It is not a one-use-only provision. On the 4th of April 2025, the tenancy still had introductory status by virtue of Section 130, subsection 2. Now, the result of this, the appeal was allowed and the district judge's summary judgment for the tenant set aside, and the second possession proceedings were set to continue. Now, if you want to follow all of this or reprise what we've been talking about here, don't forget all of the detail is in the bulletin.
Yeah, because it's quite technical. We don't often do it in the podcast. Thanks for staying with us, but I do think it's interesting. Introductory status is actually quite complicated at times. It's one for the housing lawyers out there, and I'm going to give a special shout out to my good friend Ellie just because I can. Now, Dennis, also, I've double checked Essex County Council. They are definitely going ahead with elections
right.
In May 2026.
So May. That's a live update.
It is a live update indeed. So, and on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 4, available on the LLG website now. So it's goodbye from me.
And from me too. Goodbye now.